Joining me now is Ron Coleman, Carpe Donktum's lawyer, who is going to be defending him against this completely ridiculous, in my opinion, lawsuit about his meme. Ron is an attorney who set precedent with the Supreme Court recently, proving that we can trademark names that some people may find offensive. They can't deny trademark applications based off of a snowflake's opinion that some may find the business name or a band name offensive. And it's great to talk with you, Ron. And this lawsuit, I've read through it. I think it's so absurd in so many different ways. I don't even know where to begin. Where do you want to begin with this? What I would say a laughable slap lawsuit in a sense.
Well, Mark, first of all, it's nice being on a show with you after all the years that we've known each other online. It is, I will say this much, it is a veritable feast of silliness, this lawsuit. So you don't have to be a lawyer or an experienced lawyer to recognize that there's something very, very frivolous about a lawsuit that sues, it makes claims against a guy like my client and the President of the United States as a co-defendant for anything, for anything.
Now,
I mean,
in this lawsuit, they're claiming that Carpe Donktum, falsely used their image for advertising purposes, which that would be if, in a sense, somebody took a baby's photo and put them on a Pampers commercial or something like that. This video went viral. It was already in the news. It wasn't like a private video. And so in this lawsuit, they're not even explaining what the point of it was, right? So how do you go about, convincing a judge answering these, 24, 25 different allegations that they make in this? He maliciously and falsely, put wrong text on the video that says that these babies were racist, and obviously not proving ignoring the total point that it's just a joke. It was really about CNN, not about the babies. So, here, number 13. Oh my God, without written consent, Carpe Donktum manipulated and adulterated the plaintiff's video, knowingly used a portion of it out of context, sent in an extremely distorted and false message.
There are when I say that this is a feast, there are a lot of ways we can go in terms of making the most use of these silliness of the lawsuit. And at this point, obviously, I'm not at liberty to really go into that. But I can tell you that it was clearly the product of somebody going through a sort of one of these legal horn books that list all the possible causes of action that you can have under a certain state's law or under a federal unfair competition law, which is very similar to most states' unfair competition law. And this is a form of unfair competition, these claims. And just finding those elements and trying to make them match up with the facts or the alleged facts, and using lots of scary words like intentional and malicious that are sometimes actually required under certain kinds of claims and in order to get certain kinds of damages, but as often as not are meant mostly to scare and impress people who read the pleading.
And in the description below this video, I'm going to link to Carpe Donktum's his Fundly fundraiser. You guys aren't using GoFundMe probably for their bias, the likelihood that they would cancel it. But he's trying to raise 100 grand or 150 grand, and some people who haven't been involved in lawsuits may not understand why they can rack up so much money. And I'm assuming you're a high-powered lawyer. I don't know what you charge an hour. I'm assuming $500, $700, $1,000 an hour. But even if it's $500 an hour, you're talking about thousands of dollars a day. Even if obviously you're not going to be working on this 8 hours a day, 5 days a week, but even if you dedicate 1 day a week, you're talking about $15,000 a month in attorney fees for Carpe Donktum. So we want to help him fund this lawsuit, because this could essentially drag out for 2 or 3 years, couldn't it be, with you and their legal team going back and forth? And you want to run us through why these lawsuits take so long? What are you expecting this to do? Because you're going to answer all of these ridiculous claims. A judge is going to read through that, and then you have to go back and forth with their team, and every group has 30 days to respond. So run us through the time frame of this, the costs. I mean, if it gets to having to do depositions, you're going to have to fly to meet them. And I mean, you're talking, some of these lawsuits I've seen with other YouTubers, $50,000 a month in some cases.
You're getting me very excited here, Mike. Mark. I mean, guys, I'm trying to concentrate on your questions here, but but my heart is palpitating as you describe all these ways that the fees could rack up. And in reality, we try to keep them as efficient as possible. There are a lot of ways that a lawsuit like this could go, like any lawsuit. One thing that frequently happens, and it may or may not happen here, is that one or more parties makes a motion to dismiss the pleadings, saying to a judge, even if every single word they say is true, there's still no legal claim here. And that's called a motion to dismiss on the pleadings. A motion to dismiss on the pleadings can often be done by an experienced lawyer whose rate is reasonable, but still maybe on the premium side, like mine. A motion like that, and working obviously with junior people whose rates are lower to sort of give you the raw material to work with, that can come in at under $20,000, $30,000 under the right circumstances. I've done even less expensive than that when something is really garbage and it's really obvious to the judge that it's garbage. On the other hand, in the Gavin McInnes lawsuit down in Arkansas, in Alabama, which we're still awaiting for a decision on.
Against the SPLC?
Against the SPLC, first of all, we were the plaintiff there. So the complaint was and is extremely detailed. But the motion to dismiss was vast. The SPLC threw a tremendous amount of material at the judge, and we had to respond by addressing all that material and addressing all the legal arguments. That was a pretty high-priced motion, and so even a motion to dismiss can get you easily, to the $50,000 to $100,000 range, depending on what happens and how many legal claims there are, how many factual issues there are. The judge is not supposed to examine factual issues, but in certain kinds of cases, at the end of the day, he or she really does have to. So that kind of, that response to a lawsuit, a motion to dismiss on the pleadings, usually is something that you cycle through within a couple of months after the papers are filed. Here we have two different defendants. You have Carpe and you have the president. And we may or may not be coordinating. I mean, we'll be coordinating because we're co-defendants, but we aren't necessarily going to have the same litigation goal or approach. Assume if both parties, however, make motions to dismiss, and they would be typically separate motions. In any event, that might add a little bit to the time. It's unlikely to add to the cost. Then it goes to the judge. The moving party makes one set of files one set of papers. The plaintiff, who's defending against now our motion to dismiss the claim, responds with a set of papers in opposition to our motion. We then get last licks. Whenever you're asking the judge to do something, you have the burden of coming forward, so we get the last opportunity to answer. That's called a reply brief. That whole process can take 6 weeks, it can take 8 weeks. Then it goes to the judge, and then the judge has complete discretion about how long he or she takes to rule.
Now, what if you guys get a judge that is a complete anti-Trump Kool-Aid, CNN Kool-Aid drinker, and they have their bias incorporated into their judgments? I mean, that political positions may have come into play in the past. Obviously, it's hard to maybe separate, your personal opinions from the legal positions. But in our legal climate today, it's everything's all messed up, right? I mean, what if a judge reads this and just says, "Yeah, you're terrible. We can't believe what Carpe Donktum did to these poor toddlers,"
It's possible that will happen, but it's really unlikely. We're in federal court. We're in the Southern District of New York, which is the most prestigious federal court in the country. The judges there really have a lot of self-respect. They come to work looking to do their jobs right. I do not think of this as a case that is. Actually, I should point out it's filed in New York State Supreme Court. It's not in federal court. There's a very clear tactical reason that it was not filed in federal court. It may end up in federal court. That's an issue that's still on the table. Even then, the New York Supreme Court, which is what the trial level court is called in the New York State system, especially in New York County, the judges have a lot of self-respect, and they're not nearly as political as people think they are. They also know that they're going to be reviewed, and there's going to be a lot of eyes around the country on the case. And this is also there's a free speech aspect to this, and I think unlike many of the cases that have come before judges, such as involving the president's finances, business activities, this is really a very straight. Like you said, this would be a slap suit if New York had a strong slap statute. It doesn't really apply. I think we haven't ruled it out here. So there is a point at which judges, even if they have all the political juice in the world running through them, still have enough self-respect and respect for the job that they are paid to do, that they're going to do it right. So I'm not too worried about that in this particular case. But we're only talking here about that motion to dismiss. Even if the motion to dismiss is as good as I think it's going to be, if we make it, if that's the approach we take, there's still a possibility that we lose it for any number of reasons. Could it be a political reason? I hate to think so.
And they're claiming emotional distress, and oh my God. And I mean, pretty much every one of these points can be answered with, it was a joke. The joke was on CNN, not about the kids. They didn't mention anything about the second half of the video where it says, here's what really happened. It's like they didn't get the joke. Are these parents, have they been duped by an attorney who's just going to bleed them dry for this? Or are they doing this on a contingency basis? Because they must know that this has the potential to cost them $100,000, $250,000 and drag this out for 2.5, 3 years. Are they being duped by a money, hungry lawyer? In your opinion, I'd imagine that kind of thing happens all the time, right? Where a lawyer's like, "Oh yeah, you definitely got a case," and they know there's not a case. They just need something to do.
It happens all the time. It's happening every minute that we're talking. It's happening somewhere in America. But I would never presume to look into the heart of any other man, much less an adversarial attorney. We don't know what's going on over there, what their arrangement is, whether it's a contingency, which all things being equal seems likely here, or whether somebody just wants to get his name splashed around in the papers.
I sued the president of the United States for picking on these poor toddlers. I mean, is that another, it looks like there's a political tactic to try to just smear the president by saying, oh my God, he disrespected these poor innocent toddlers, and he's such a terrible person. He's picking on babies now. I mean, that seems to be another aspect of this, isn't it?
I mean, the transparent fallaciousness, falseness, preposterousness of the factual allegations that Carpe and the president sat down and made a conspiracy. I mean, Carpe, God bless him, achieved something that all of us who are supporters of the president would love to achieve, which is to get invited to the White House and bring in his family and have a day that he'll remember for the rest of his life. Not a lot of conspiring, I think, during that meeting, and it's absolutely ridiculous. And so I think the link to the president here doesn't seem to do the plaintiff any favors. But they have they have their calculus. They
You
know what
know,
they're doing, I suppose.
because this wasn't even I guess they're claiming that this was like a campaign ad, but at the end of the video there wasn't like a vote for Trump or anything like that. Obviously, if somebody used, if Carpe or anybody used these images of these kids in a commercial for baby food or diapers, that would be misappropriating their image. But do you expect that a judge is going to dismiss this, or are you going to have to just drag? Is this going to be drug out for 2.5, 3 years, and then in 30 seconds you can explain this to a jury of fellow human beings and be like, it's a meme, it's a joke, it's making fun of CNN, spinning fake news. It obviously meant no disrespect to the kids at all. The joke is on CNN. Period. Ladies and gentlemen of the jury.
Well, I mean, you asked what we would call in the courtroom a compound question. Let me try to break it down a little bit. I mean, one of the first things you said was that now I don't even remember what it was. That
is this going to go to a jury? Do you think? What are the odds that it goes to a jury? And that
that's really unlikely. Okay, even first you got the motion to dismiss possibility. In the if there isn't a motion to dismiss, or if a motion to dismiss is denied, there would be some discovery. Once the discovery takes place, I think that a judge in this situation would probably make discovery pretty quick and dirty. They have control over the schedule. After discovery takes place, there would be a motion, what's called the motion for summary judgment, which is a sort of fleshed out version of the motion to dismiss. It says, Judge, you said we couldn't dismiss the case based on the allegations as if they were true. Well, they've had the opportunity to prove whether or not they're true, and they haven't. And the evidence they've come up with is so paltry and so absent that we shouldn't waste the time of a jury having a trial, and then the judge decides whether or not that argument is the case. So getting past a motion to dismiss if one is made, and then getting past a summary judgment motion if one is made, going to trial. I mean, look, I love trying cases. Love it. I love trying easy cases too. And I like juries. Sometimes I think juries might even like me.
Well, because instead of then just one judge having to read through their allegations and your responses, I would think that if you can get a jury of 12, fellow human beings, in 60 seconds, they could decide like, wow, this is ridiculous. Yeah, not guilty. And then I guess because this caused Carpe Donktum's Twitter account to be taken down, in Carpe's statement, he said that he's considering taking action against them to, in a sense, get them to retract their claims. Are you gonna do that? Is that still something that Carpe is considering?
That's something Carpe is considering, and that we're considering along with him. Yes, I mean, they went through the trouble of bringing him to court. They have done him some damage, and he is in a good position now to take action to get some compensation and perhaps get reinstated somehow. I mean, remember, Twitter's not a party to this lawsuit, but it is entirely possible that would happen. That's certainly on the table.
Because if the parents are on the hook for, I would argue, millions of dollars in loss that Carpe is now having lost because he became a huge superstar over the last year, 2 years, several years. He has 20, 30 years left in him. I don't know if you can sue for future compensation, but just the fact that he's not able to reach the millions of people anymore like he was. If the families are on the hook for the loss of his future revenue and viewership and fame, if you want to call it that, they may have to go to Twitter and beg Twitter, say, oh, please retract this DMCA, or please reinstate his account so that we're not liable. And Twitter doesn't have to really do anything that they don't want to, but just then now Twitter's going to be screwing over the parents instead of Carpe Donktum, who obviously they want to penalize as much as possible. So I guess what factors are going to go into that? Because he's on Parler, Carpe's on Parler, but it's still kind of a niche platform, not as mainstream as Twitter. So when's he going to be deciding whether or not to take that course of action?
Well, I mean, you asked two questions. One is what factors would go into the compensation, and one is whether is he going to seek that compensation. When someone is damaged by someone else's actions and seeks legal compensation for that damage, he is nonetheless obligated to mitigate the amount of his damages. In other words, if someone gets fired wrongfully, he can't then say, well, because I'm going to make a lawsuit, I'm going to file a lawsuit against my former employer, I'm going to sit at home for the rest of my life. No, you got to try to find a job. And if the new job pays $20,000 less than the old job, now we're starting to see the quantum of damages. Carpe loves what he does, and what he does, he's doing it in as many other platforms as he can. But yes, having been kicked off Twitter is a gigantic difference. That's the kind of thing that we sued Care for on behalf of the Laura Loomer in a case where the appeal is now pending. We believe it's very clear that there could be third-party liability for getting somebody tossed off.
The tortious interference, where the third party is interfering with your contract between the social media platform.
Contract or an expectation of economic benefit, yeah. So we're looking at that. We're certainly exploring that. As you say, Carpe did include it in his statement, and it's something that we think is a real possibility. That does have the implication that the litigation, even if there is a motion to dismiss, if it's coupled with counterclaims, isn't necessarily going to be over all that fast. Now, they may in turn make a cross motion to dismiss our pleading, or their own motion to dismiss our pleading. That's now you're seeing how the dollars start to add up, and the time starts to add up, and for us, the fun starts to add up.
And I guess, what are they expecting out of this? I suppose publicity, possibly. They're just expecting the president to offer them, $100,000, and oh, we're so sorry. Here's $100,000. Yeah, well, yeah, here's $100,000. Just go away. What do you think they're expecting out of this? What damages do they actually have?
They don't have damages. They clearly don't have damages. And they clearly don't have a valid legal claim. People bring meritless lawsuits all the time, sometimes hoping that there will be a settlement because, what's called a nuisance settlement. The Trump organization, I think, was not in the habit before its head became president of making payments, nuisance payments. But I mean, any large corporation does. It's just part of the cost of doing business. But at this stage, it would obviously be a very bad precedent for the president to do that. I would think. I'm not representing him in this case. To make any kind of payment, because all that does is invite the next schmo to go and file a meritless lawsuit, hoping for his payday. So I imagine it will be very vigorously defended by the president. What the tactics and strategies of that team are, I do not yet know.
I mean,
what they intend to get out of this, Mark, I cannot tell you.
And doesn't this case have the potential to set a new precedent regarding memes? Because, you see these crazy feminists that become a meme of themselves for months or perhaps even years. And what's to stop them from arguing and saying, oh, you made a meme about me and you have a Patreon account and you specifically made the meme to, to gain followers and use my image commercially. Doesn't this case have the ability to set a precedent for memes in general?
It might. First of all, there's the open question, I think, of what is considered a meme. Is this a meme or is this just a parody video? Yeah. I often think of memes as being something that is either static, some kind of picture, or if there's motion, it would be more in the nature of a GIF or something that's 2 or 3 seconds. This is arguably a parody video. That doesn't, as far as I believe, make any difference what we call it under copyright law. But interestingly, there's no copyright claim here, which would, anyone looking at this, it's very obvious that an attempt was made to find a way to sort of make a copyright claim without making a copyright claim, because there's no copyright claim.
I'm reading through some of these complaints here. The defendant, Carpe, he added fraudulent text over the manipulated video, further distorting it, improperly applying the CNN chyron, referring to it as breaking news. I mean, come on. He maliciously added the font. Oh, the toddler runs away from the other baby. He knowingly, he created the false video knowing of its falsity. Well, it's parody with reckless disregard for the truth. I can't read this without laughing. I mean, so is the judge going to see, you're going to send the judge a video, a thumb drive with the video so that he can see it in its entirety, I suppose, with your response to this insanity?
Well, there's no getting around that. I mean, the judge has to see the video in order to make a decision. First of all, regardless of whether there's going to be a motion to dismiss, if the judge hasn't already seen the video, I imagine the judge will have seen the video before the initial conference with the attorneys, just to understand what the case is about, and whether we submit it or whether someone in chambers fires it up on their computer. It's something that is entirely relevant. If someone makes a lawsuit involving defamation, you don't have to read every single defamatory article if you're the judge. You read what the parties put in front of you. You're talking here about a very short piece of video, and look at it, and the judge is going to very quickly get a sense of what's going on here and why his time or her time is being wasted.
Unfortunately, I don't know if you want to explain SLAPP lawsuits. And I guess we should have explained what discovery is for those who don't know. But, a SLAPP lawsuit, you want to just explain what a SLAPP lawsuit is and why you can't file a motion to dismiss based off that in New York?
Well, there are states that have statutes called anti-SLAPP lawsuits, and they are meant to prevent lawsuits like this, lawsuits where people find obscure ways of suing people for saying something. I have litigated SLAPP lawsuit issues in California, and I've written on the topic of SLAPP statutes, which I'm actually not necessarily an advocate of. And so some of my First Amendment lawyer friends have very different views of it than I do. However, there was a recent decision in the Ninth Circuit which gave me a little bit of hope. In my view, there's always been a bit of a problem with the application of SLAPP suits to federal claims or use in federal court. They're state law creations. Now it's a question as to how applicable they are to state law claims, in state courts. But different states have different policies, and New York and in New Jersey, where I primarily practice, don't have SLAPP statutes. Or New York does have a SLAPP statute, but it's really a low-level kind of thing. It deals mostly with comments involving government, and doesn't no implication of that here. So we're not going to be able to and one of the things about some of the more powerful and effective anti-SLAPP statutes is that they not only make it possible to dismiss a lawsuit, but they also make it possible to recover attorney's fees for the filing of a SLAPP lawsuit. And that's a big deal because it's a general rule under what's called the American rule as opposed to the English rule. Each side bears his or her own costs almost regardless of the outcome. There are some statutes where that rule is put into play, and the judge has discretion or sometimes no discretion to award fees. And in many states, anti-SLAPP laws do come with attorney's fees. So the choice of suing Carpe, who lives in the Midwest, in New York, certainly had something to do with the fact that New York is basically a SLAPP-proof jurisdiction. On the other hand, New York judges both federal and state New York judges are very, very familiar with media-based claims. They see them all the time. New York, what's left of New York, is still the media capital of the country and probably of the world. So judges are very familiar with these kinds of claims. They aren't necessarily big fans of them. So it was it's a mixed bag here, bringing this case in New York. But I'm glad they did for my sake, because it'd be harder for me to work with Carpe out where he lives. Although I would have taken the case no matter what, because we're friends, and he wants me on it because I'm great at this stuff.
And and then again, I want to leave a link to the fundraiser page down in the description below, because I want everybody to support Carpe. And I called him and congratulated him. Ordinarily, if a friend of mine was sued, I'd be like, "Oh man, this is terrible." But I called him and I was like, congratulations, man, because you can't have a better co-defendant than the president of the United States. But I'm sure that it still is. It's a mess. It's stressful. It's going to be costly regardless of what happens. And, that's why, just from me, I spend thousands of dollars a year just consulting with my lawyer on potential things and having them review contracts, or potential problems come up. And I say, hey, what do you think about? And, 30 minutes, an hour goes by, and, there's $500, there's $700 gone. And that's,
litigation is very expensive.
That's what it costs. And so, when people see the fundraiser, oh, he's got $100,000, that's fine. I mean, this could be extremely expensive. And, just like I said, just doing the math, even if you're a bargain lawyer, $500 an hour, you're talking about thousands of dollars a day, just working on the case, researching, filling up briefs, not to mention if you have to go and travel and do depositions and stuff like that. So Carpe it's going to be, it's a blessing and a curse. It's kind of, on one level, I'm sure, funny for him, but pretty stressful, not something anybody really would want to choose to be a part of.
I would think not, but it does put him back into play and on the map in Twitter. People are talking about it. Twitter's really important to him, obviously. Everybody wants to be vindicated, and this is an opportunity for a sort of vindication for him. And it's also nice to see how well his Fundly has done so far. He's a really well-liked guy. And it's nice to see so many strangers are willing to help out with $5, $10, and more. So, and that's one of the few things, about social media, which has been so destructive in so many ways of the social order. It's been great for me in a lot of respects, but I probably would be getting a lot more sleep if it weren't for social media, but maybe a lot less work. But the ability to do crowdfunding over Twitter, even if some of the crowdfunding platforms are so politicized that they won't let conservatives raise funds on them, hell with them. There are ways around them. There are still options. We're not locked down completely yet. So, that's an encouraging thing. I'm sure it helps them get to sleep at night.
And I guess this is a perfect example of the Thestreisand effect, because if these parents, as they allege in their complaint, they were just so horrified that the president did this to their kids, well, now everybody wants to see what the fuss is about, everybody who missed it now. And now people can show it, and it's clearly fair use in a news channel like mine, and I guess they could sue, but they have zero standing whatsoever regarding that, because now we're showing a little clip of it. Here's what the fuss is about. Now they've just opened the door for fair use to be applied in discussing this lawsuit. Now everyone's seeing the meme.
But that cuts both ways. That cuts both ways, because what a plaintiff can say is, look, it's out there, and it's going to be out. There's, we recognize there's nothing we can do to stop it from being out there, and we acknowledge that the lawsuit is making it more out there than it otherwise would be. But the fact is, we're still, or our child is still, entitled to compensation for the tragedy and the pain and the horror of it being out there. And there is something to be said for the idea that you shouldn't be penalized for seeking compensation, or whatever you're entitled to, for a wrong that's done to you, if merely because it's going to be repeated in the papers. But I think you're right. I mean, it is hard to think if your concern is really with the best interest of your child, how can it be that you want to regurgitate, what was swallowed?
And as you know, and we'll wrap this up, and I appreciate your time. Twitter is just a blip on the radar. It's like an appetizer, whereas YouTube is more of a four-course meal. So everybody would have forgotten about it. Maybe the parents got a few text messages from their friends, like, "Oh my God, the president just tweeted." Okay, yeah, maybe it was a little, uncomfortable for them, a little disappointing for them to hear that. But in 24, 48 hours, it's gone. Nobody's going to remember when these kids are older. Nobody's going to remember, oh my God, you were those babies that, President Trump retweeted. Nobody cares. Nobody doesn't, no one's going to recognize them. And then, their names weren't used. It's just crazy. So I appreciate your time. We'll keep in touch as this thing unfolds or drags out as as the legal system is now slow to the, with the coronavirus, everything seems to be quite slowed down. So we're wishing Carpe the best. It's a blessing and a curse, I suppose. It validates his hilarious meme making work, but at the same time, it's now it's a little hassle for him, and so we'll keep in touch, and hopefully you'll keep us posted on how this unfolds, and then at some point in the future we can celebrate when we are victorious.
Please God.
All right.
Thanks
Thanks again, Ron. Ron
great
Coleman, and anybody wants to support the law, support Carpe Donktum against his against what I would say is attempt to censor and silence him. The link is in the description below to his Fundly page. And thanks again for your time. And stay tuned because we'll have some updates for you at some point in the future.